Okay.
Good,
Well, I'm gonna.
good, good day, everyone, and welcome to Keep Six Empowerment to Unlock the Justice System. Today, we have two wonderful lawyers joining us today from Toronto, Ontario, Canada. First of all, we have Brian, we have Allison. Today's discussion, we're going to be discussing about dangerous offender regime and how it affects our community and our young people. Allison, good day, and thank you so much for joining us. Brian, thank you also. Allison, I would like you to tell us a little bit about yourself, and I know you're a very busy lady, and you also run a law firm in Toronto.
True. I've been a lawyer since 2006. I spent the first 15 years of that at a firm called Lockyer Campbell Posner, or some version thereof. And then just over 2 years ago, me and two other lawyers founded our own law firm. So we do solely criminal defense, but I do a lot of serious trial and dangerous offender work.
Thank you so much. And Brian, it's my pleasure to have you here today. Please tell us a little bit about yourself so our audience can be familiar with you and your firm.
Thank you, Richard. Um, I was called to the bar 2012. I worked with Allison at Lockyer Campbell Posner for a while, and then I started my own law firm 2019. We are called Be Defended Professional Corporation. There's three of us there, and I'll leave it at that for now.
Thank you so much, and I appreciate it. Now, today's topic is a topic that's been around for some time, but unfortunately, I wanted to have you individuals here because I'm very much aware that you specialize in this topic, and the topic is dangerous offender and the regime itself. Now, dangerous offender was something that was used for very violent and also sexual offenders years ago. I can recall, or maybe our viewers, one of the person I could recall was under this regime going back would have been Paul Bernardo, and before that there was another gentleman. I think his name was Whitmore or something of that sort. But anyhow, now it has come to be a very popular sentence that young people are receiving. At Keep Six, we're getting a lot of calls from individuals that have been incarcerated for a number of years under this designation. I would like for Allison, if you could maybe shed a little bit of light about exactly what the dangerous offender regime is all about.
Yeah, I mean, in short, it's a an available sentence that can be used for anybody that's got two or more convictions for serious personal injury offenses. And it essentially puts you under state control for either an indeterminate period, which is an indeterminate sentence for likely the rest of your life, or you can get a determinate sentence plus a 10-year long-term supervision order, which is basically 10 years of parole. But essentially, the most common, I think, sentence is an indeterminate sentence, which means you're potentially in jail for life, longer than a life sentence.
So basically, it's fair to say that a person that is under dangerous offender regime is worse than a person who's charged with a murder, with a first degree murder, because that person on a first degree murder has a release date, to say out of fairness.
Yeah, I mean, you don't. If you're on a life sentence for murder, you don't necessarily have a release date, but because you still have to go for parole. It's a life sentence with a certain number of years until you're eligible for parole. You don't necessarily get it. But statistically, you're more likely to get parole if you're convicted of murder than if you're declared a dangerous offender.
Right. Now, Brian, what in your area and your experience, how do you see the justice system and our young people with this regime taking place?
Um, What I would say about the dangerous offender regime is that there's no doubt that the numbers are tracking upwards. The current legislation that we have it's from the criminal code. It comes through section 753, and it started in 1978, and it's steadily been creeping up. Like I'm just staring at the statistics on my other screen, and we were seeing about like 0 to 10 dangerous offenders back then, whereas now there's more like 60 to 70 dangerous offenders every year. So that's across Canada. So that's a small number compared with all the people that go in the criminal justice system, but it's also increased by sevenfold over the decades that it's been in place. So it is the most. I agree with Allison, and I agree with you, Richard. It is the most punitive sentence because I agree with Allison, and I think the statistics bear out. You're more likely to get parole after you're convicted with murder than you are if you've been designated a dangerous offender with an indeterminate sentence. But I wouldn't say it's a popular sentence, and in my experience, most of the dangerous offender clients that I've dealt with, they are older. I've not encountered many younger ones, but it's concerning. It's for me, the most concerning part about it is the fact that so few dangerous offenders are successful with their parole applications, and it seems obvious that they face huge barriers in doing so because the fact that they were designated in the first place.
All right. Now, I understand you're saying the older individuals that you've come across under that designation. Now, as for the older individuals, Allison, what's your take as clients that you've come across handling in an age gap and ethnic background?
They are older for the most part, but you are starting to see them younger and younger. And I've had Crown attorneys tell me that they've been told by the Ministry of the Attorney General to bring these applications way more often. So that's why. And it used to be that it's always been that you only needed 2 or more convictions for serious personal injury offenses. It used to be in reality, people tend to have many, many more than that before the application is actually sought. That's definitely not the case anymore. I've had a few where it really is only upon the second conviction that the application is brought. So, and that I guess is why we're seeing people with younger and younger ages being subject to these applications. In terms of ethnic background, it's the same thing you see for the general prison population. It definitely is more Black and Indigenous and other racialized minorities, the same as it is just in our jails in general.
Right. Now, that's interesting. The other thing that comes to light is when you are dealing with, I know, Allison, for instance, you do a lot of parole hearings. That is something that you also specialize in. And what is it like for individuals when they're going up for the parole? Because, and again, I'm just asking for a breakdown, is even to walk our audience through the process. Like an individual, say, maybe sentenced to a dangerous offender regime with a sentence of maybe 8 years or 10 years, and they're able to go up. How often are they able to go up, and how soon after their parole eligibility?
I think you're first able to go, I believe, after 7 years.
Yep.
But I mean, it's a paper exercise. It's a complete and utter waste of time. You're not going to get parole. It's for show, if not, and nothing else. The reality of a parole hearing, just sort of in short, what happens is your institutional parole officer writes their report to the board recommending either release or deny of release. Then you go to, I mean, essentially a pointless hearing because 99.999% of the time, what your parole officer recommends is what the board is going to do. There's really, it might as well be a paper hearing, quite frankly, because the board will never go against, except in very rare circumstances, what your parole officer says they should do. And parole officers are given very strict guidelines about when they can and cannot recommend parole. There's no room for discretion. And for any dangerous offender, they're going to want to see, I don't think I'm exaggerating really to say decades of stability. They're going to want you to, cascade all the way down to minimum and, have your toes completely clean. Otherwise, they're going to be afraid, I think, to recommend it. And, you hear the public backlash about what happens when someone like Paul Bernardo is just moved to medium security. You'd think he was just, given a house for free somewhere in, Mexico, all expenses paid, the way the public reacts to it, right? So parole officers are going to be very, very hesitant for that reason to recommend it. And for that reason, the board is never going to grant it. So it's paper hearings for show and not much more.
And thank you so much. And the other thing I wanted to enlighten on, I understand that you outlined that the Blacks and Aboriginal are the number one individuals who get this kind of sentence. But when we look at statistics, we know that all of our institutions, it's already populated by the Black offenders and Native across the board. This to me seems more or less it's another way of warehousing bodies or individuals. What's your take on this practice? With what you've seen with your clients.
I don't know if I'd describe it as like the effect is warehousing of individuals. I'm not sure that's the specific intent. It's the result. I think it's really a reflection of a system and a society that is completely incapable of addressing the underlying issues that land people in the criminal justice system in the first place. And so this is yet one more effect of that rather than necessarily the intention behind it. It's certainly the reality.
Right. Okay.
And I would add that it's also, I think, in part the disparity in sentencing between what white offenders get as sentences and what racialized minorities get as sentences is pretty stark. And because of that, it leads to more harsh sentences being reflected on people's criminal records for, their first offenses and their second offenses and et cetera. And that kind of snowballs, right? So ultimately, you see, racialized offenders get harsher sentences, and that is used to justify later on down the line bringing a dangerous offender application, et cetera. So it's like a snowball effect, all of those things.
Right. Very, very interesting. Thank you. So, Brian, to you now. We regarding the individuals that you come across in these applications, what are the most common offenses that you would say that these applications are brought forward towards individual? I've just came across an individual who reached out to the organization who's under the regime with break and enter. but this is a residential break and enter also. Um, Could you just give us a bit of light on that?
For sure. I I'm pretty confident in saying I have not noticed a pattern in terms of offenses that are more likely to result in a dangerous offender designation. And there, I will say there's a separate section within the statute that makes it easier for the Crown to obtain a classification or to make an application for someone to be designated as dangerous if there's a sexual offense involved. It's sort of like a there's several different categories through which the Crown can apply, and that kind of allows them to skip a step in a sort, in a way. I mean, you've referenced people becoming dangerous offenders with break and enter conviction. One of the more recent cases I worked on, I was working on the appeal for it. The client, his most serious offense as part of that application was criminal harassment. He hadn't hit anybody. He hadn't actually caused violence. But remember what Allison was saying towards the beginning of our session. The requirement is that it be a serious personal injury offense. That's not paraphrase. That's the specific wording of the statute. And you would be surprised. I think when most people hear the word serious personal injury offense, you think it would be an aggravated assault or discharged firearm or aggravated sexual assault, something along those lines. Right. But criminal harassment counts. And in that client's case, I mean, the actual act was leaving voicemail messages and sending messages, and he was designated a dangerous offender indeterminately. So I don't see, I have not noticed a particular type of offense that makes people more eligible or more likely to become dangerous offenders. But what the way that this is designed, the way that the law is designed, is to designate people who have demonstrated patterns of behavior. And it's worth stating for your viewers, the real test is one of intractability. That's the word that comes from the Supreme Court. That's not the word from the statute. It comes from a case called Boutillier. And that's the real question that a judge is faced with on a dangerous offender application. Intractability is a question of whether or not a person's behavior can be changed. So first, the Crown has to establish a pattern of behavior. And that's really what brings about the dangerous offender application in the first place. But the question that they need to answer positively to the judge is that it never will be changed. And there's a lot of discretion about that. And that's why that's why I find the regime it's very powerful. So I've certainly thought sometimes that it's more powerful than it should be, and it gives a lot of discretion to the Crown, because even if they fail on designating someone a dangerous offender, it's very easy. It's very, very easy for the Crown to designate someone a long-term offender. And once they do that, it's all that much easier to designate someone a dangerous offender. It's a very significant stepping stone towards that. So that's a long-winded answer to your straightforward question.
Thank you. So, and Allison, back to you. Could you give us an idea of the steps? Like once a person says, for instance, before a crown goes through an application, what are the process for the crown to go through the application? What are the, and then for that person to be actually become a dangerous offender or a long-term offender?
So the Crown has to bring an application for an assessment. So they do that before the sentencing judge, whoever it was that the person either was convicted by or pled guilty in front of. Um, and that's, I mean, that's gonna, it's shall, they will get that order for an assessment. Then they get the assessment done by whatever expert they pick. Sometimes they'll let you, sort of collaborate to pick to do the assessment, but there's, the Crown experts, if I can put it that way. Um, Once they get that, and this process, it takes months and months, if not years these days. It takes forever.
Right.
Usually the person is sitting in custody while that's happening. Then they get the report. They send it off to the Attorney General to get permission to bring the application. Once they get that, which they will, there's a hearing set in court where the Crown's expert comes and testifies. Sometimes the defense will get their own expert to testify as well. And, they'll call at the hearing, they'll always call parole officers, staff from CSC, etc., to testify about how there's no possible way that anything other than indeterminate incarceration is going to work for this fellow. And then, the judge will make their decision. It's the same every time.
So, in other words, it's more or less a dead end street for that individual once that application goes in, pretty much.
Yeah, I mean, now more and more.
Sorry, go ahead.
Yeah, I was just going to add more and more. I am seeing reports from the Crown's experts come back saying, "Well, hang on a minute here. No, this person can be controlled in the community." And so the Crown's not going to get their indeterminate sentence. And I'm seeing that more and more, likely because the Crowns are bringing these applications more and more. So I'm not sure more. I don't know the statistics about whether or not there's a correlation between the number of applications the Crown is bringing and the number of indeterminate sentences being handed out. I don't know if that has increased along with the increase in applications, but that's the process.
Richard, if you don't mind, I was just going to say in response, well, following along with what Allison was saying in response to what you said, I had one recent case right along the lines of what Allison just described, where the Crown they got permission from the Attorney General to pursue a dangerous offender. They took that initial step of obtaining the psychiatric assessment. The psychiatric assessment came back, and like the circumstance that Allison was just describing, the doctor actually, I mean, he was quite fair and said he does not see that the dangerous offender requirements would be made out. He found that the client was treatable. And to that Crown's credit, they abandoned it. They abandoned the dangerous offender. But let's keep this in context. I mean, that client was already serving a double-digit penitentiary sentence, and he was already facing, I think, 7 years on top of that. So he is probably, based on what Allison and I have already said, his chances of parole are far better in that circumstance than they would have been had the Crown pursued the dangerous offender. And Allison does more of these than I do, and that was a real one-off. But to Allison's point, because they're pursuing these so often, I think that's why we see circumstances like that.
Yes, thank you. So even I was able to get some statistic here from one of our law students, did a little bit of research, and um, what we have come up with is that there are 462 Aboriginal women offender classified in minimum security under dangerous offender um, regime at the present time. We have 50 Black women, 74% classified in minimum security. Um, the thing about it is that it seems very difficult for the men to get down to these security level. And the other thing that I find is that CSC, the parole officers themselves, or even within CSC, don't know how to manage a lot of these circumstances.
Yeah.
So
Mhm.
individuals, and again, it's fair to say they're just left to be housed until um, I, from what I've learned in my own little research, is the fact that once they get to 65, then they have the opportunity of cascading down to a lower security. That's kind of the way I've learned that CSC operates. But otherwise, they are just there waiting or until they die. Right.
They're
Um,
the ones that can always wait, right? There's no urgency to deal with them or help them or anything else because, they're going to be in jail for decades more to come. And so why prioritize helping them with anything?
yeah, it's very, very disturbing. It's to say the least. So with that said,
Yeah,
Mike, go
Richard,
ahead, Brian.
I just want to comment on that. I mean, that's another thing that really concerns me about the regime, because a common thing that you see at these dangerous offender like the witness list is almost the same for every dangerous offender hearing. You have the Crown psychiatrist, and then you have a representative from CSC, from Correction Services Canada, to speak about the type of counseling that they're going to get. And Allison and I both do parole hearings regularly, and we deal with those clients getting that counseling. And there's a real disconnect between what you hear about in court, what's going to be available, how quickly it's going to be available, and how intensive it's really going to be. There's a real disconnect between that and then what Allison and I hear about 5, 10, 15 years down the road when they've actually done that counseling. There's a huge delay in the counseling. And I mean, you can sense from what I'm saying, there's a real disparity between how effective a judge hears that it's going to be, and how effective it actually seems to be. That's one of the biggest problems with the dangerous offender regime for me, because the whole purpose is to give these people treatment so that they might actually succeed with a conditional release or day parole or full parole down the road. But it just doesn't work that way. In my experience, it doesn't seem to work that way.
So what
Okay.
about? Thank you. So what about your clients that even on the long-term supervision order? How with for them for programming to even cascade to even be able to reach that expiry date? How have that been?
It's so much. It's first off, it's much less punitive because of the limit, right? A long-term supervision order is they max out at 10 years, and a lot of it can be served within the community as well. So it's just shorter, and I would say that again, speaking completely on the behalf of the clients that I've dealt with, I find the long-term offenders who or individuals who are DOs who are subject to long-term supervision orders in the community, I find that the treatment within the community is more effective. All in all, it's more positive, and it's much more representative of restraint, right? Like we've said it before, but it bears repeating. The dangerous offender indeterminate sentence is the most punitive sentence within our criminal code, more than for first-degree murder. A long-term offender or a long-term supervision order specifically, it's a ways back from that. It's much less punitive, and in my experience, it's more successful.
Right. So, thank you for that clarity there. Now, one of the things, Allison, and then I'll go over to you on this here. When it comes to the individuals that you have represented, and you continue to, where do you see CSC taking a much more different approach, even when it comes to their parole officers and being able to manage these individuals? One of the factors that has come up is the fact that they're always being violated. All right. As soon as they're starting to make that headway and they feel their foot is in getting, a sense of stability, they somehow get violated.
You mean people that are serving long-term supervision orders?
Yeah.
Oh yeah, it's constant. They will use, I mean, if you're 5 minutes late, going back to the Keel Center, you might be violated. It's common. I haven't seen any change in it. It's always been that way, but they will use any excuse definitely to violate them. Now, there does seem to be some restraint in terms of laying charges of criminal breach of long-term supervision order. But definitely violations that land people back in jail for however many days or months are extremely common. Anything will get you there.
And the sentences are very high. I've done one of those hearings where they've laid a breach of an LTSO, and it's not like a breach probation. It's not like a breach bail. The range of sentence. You're often looking at a penitentiary sentence for breaching an LTS. Like it's super serious.
Yes.
Right. Okay. So Brian, to you, what do you feel that would be even more positive or helpful for individuals going through it, like structural wise, even when it comes to, I'm sure you might hear this, that even within CSC themselves, they're not able to relate to these files when they receive it. It is something that is new to a lot of them. They don't have the capability or even the knowledge on it. To me, I was fair to say they don't even have the training of how to deal with clients like that.
Well, I unlike most problems in our criminal justice system, I don't think it's complicated. It is purely an issue of resources. It's purely an issue of funding. What one thing. I'm answering the question, but I'm citing Allison in my response. Allison wrote an article in one of our law magazines about the delay in counseling that's made available to federal inmates, and for your viewers, that's inmates who have a sentence of 2 years or more. And it's actually become a big part of the advice I give clients who have decided that they're going to plead guilty, and we're trying to determine what an appropriate position is. My experience, and I've spoken about this with Allison on a number of occasions, my experience is that it is easy when when offenders are sort of on the line, looking at an 18 to 24 month sentence in the province versus a 2 year to 3 year sentence in the penitentiary, I often recommend that if they're serious about parole, they're better off before the provincial parole board in a provincial jail, because there is a systemic delay in the availability of programming within the federal system, so that for inmates who are on those lower sentences, they're waiting many months, sometimes more than a year, to start the programming that they need to do in order to get a recommendation for parole.
Parole.
And if their institutional parole officer that Allison referred to, if the inmate has not completed the programming, they're not going to get a recommendation. And if they're not getting a recommendation, they're just not getting parole. I mean, it's a very exceptional circumstance where they might, I don't know of any. And so that's looking more on the lower end, but speaking to the topic about dangerous offenders, I mean, it all cascades down. If there's the delay in programming, they don't have the funding for the programming, they don't have funding for a properly qualified psychologists, psychiatrists, social workers, psychotherapists who might be able to assist these inmates in actually rehabilitating and achieving the goals of the parole board. So it's purely a resource issue from my perspective.
Right. And that's always been like that across the board for years now. I mean, it isn't something new. Now, one of my concerns would be, I'm sure you all heard, and Allison, you probably caught this on the news, but Mr. Ford announced a while back about building more jails and tougher on crime and so forth. Now, building more jails and tougher on crime. That
I've never heard him say he wants to build more. In my experience, they just pack him in. They just triple bunk. And I'm not even joking. I have clients who spent 6 months, 3 inmates to a cell built for 2. Sorry, but
yeah,
I agree with you though.
I know. So I mean, I wonder where we will be going here now, looking at this new Mr. Ford's tough on crime that he is outlining. And when you address about even the programs and stuff, and my theory is you can lock up as many people you want, but we always have to keep in mind that society, they have to come back out to society sooner or later, one day, no matter what.
Right.
So it's important. I always feel it's important to invest into the mental health part, the psychiatrists, the psychologists, psychotherapists, and programs and so forth, because these are what individuals need to sustain in life, but also to reprogram and find out the struggles that they've gone through or whatever is causing that effect of the ripple effect, right? And I just hope that someone could actually maybe listen to these theories instead of trying to build more jails or be holding individuals in.
Yeah, I mean, the good news is he doesn't have as much power as he thinks he does, because newsflash, Doug Ford, the sentencing regime is all done by the federal government, not you. But sounds good on a news bite to get votes, right? So why not say it?
Trudeau's no better. Trudeau's even worse. It's like,
that's true. Yeah, fair point. So, but one thing Ford has done, which I think has a not insignificant ripple effect, is he's putting together, and by him I mean him and the Attorney General, all these specialized teams of bail crowns whose one and only job is to get people denied bail. And that just, I mean, it might seem like a small thing, right? Somebody, their first arrest for a gun or whatever, they get denied bail. But that's what starts the whole process, right? Because you get denied bail, you start to become institutionalized, and you get back out, and now you've got no stability in the community, and so you resort back to, you know, whatever life of crime you were starting to lead into when you got your first charge. And that's how this all starts every time, right? You don't, the vast majority of people don't just wake up or come out of the womb dangerous offenders. It all accumulates, and that's a big part of it. So in the long run, I think denying people bail, rather than giving them a chance to rehabilitate while on bail, um, gets people started down this road of institutionalization, which ultimately will result in more people getting harsher sentences and more dangerous offender designations to some extent.
Yeah, definitely. I agree with you on that. I was hoping that also the fact of the programming, because I find that even in some majority of the individuals, they're always seeking the counseling and the mental health aspect of it. They've gone through some kind of trauma institution of some sort, from the school system to maybe the welfare system or the jail system. So these are all factors that all comes together. It's very fortunate that even uh, last year we had in our gangster tuition program, we had 100, I think it's 167 individuals went through the program, and we had a zero incident rate. Not one person was rearrested or violated or anything like that. Now, one of the things that we did do was focus on that whole mental health piece and go back all the way to their childhood, and look for traumas and things that they've gone through to to address these things. So it's quite clear that right there that there's a statistic that shows that within Keep Six, we've got that statistic that shows that this formula works. So maybe it's something that our government needs to start looking at and take that to help her community. But again, it's a business, so it might affect the income for our prison business from Corcan and everything else.
Yep.
So go ahead, Brian.
Oh, I wasn't saying it.
Sorry.
Echo.
Yeah. So just to get back here, how about one more thing I just realized here I had in my list here? Youth. So the regime itself only covers adult. You have to be 18 and up. Is that correct?
That's my
Yes.
So, have you had an individual, a case where a person was charged as a young offender and then cascade over to adult, and then an application was put in?
Yeah.
That's something.
Yeah, I've certainly had cases where people started their criminal records as YOs. Yeah, definitely.
Yeah, so that's another aspect we need to look at, even with her young people, and going down that path. I just want to say, I just want to ask Allison. Allison, is there anything that you would like to express to our community and our viewers about this whole topic here? Navigating through it, or even young people and their choices, and getting into this situation.
I mean, it starts young, right? Like it's not really the onus is on society, as far as I'm concerned, more than it is on individuals to put those supports in place and stop the life of crime before it starts. But that's a whole societal issue. Like, funding needs to go into supports and communities and all the rest of it. But it's as a message to kids, it's easy to get wrapped up in this. Like, Crown attorneys are bringing these applications far more frequently. They've been told to. And like Brian gave a couple of examples of, you might think that you have to, cut off people's limbs and stab them 50 times to be subject to this, but you don't. It can be something nonviolent. So, it's kind of a lesson for everybody to keep in mind. And, for parents or community supports, whoever, start the intervention young.
Right.
Because it's not, people don't wake up, with very rare exceptions, and I even need some convincing on that. People don't wake up bad, violent people. They're a product of their experiences. So if you start the intervention young, you're far less likely to fall victim to this regime.
Right. And you, Brian, your take?
I mean, I agree with Allison. There's no advice that I would give because I don't see it as being on my clients to prevent. I mean, what we are talking about. I mean, everyone should do their best. Everyone should try and stay out of trouble. But the clients that I've represented in these situations, ordinarily, almost entirely, have really, really sad stories, and it's part of why they have Youth Criminal Justice Act records. It started early. They were abandoned or abused or both. Foster parent, they have CAS files, and it's so sad. So I don't think I have advice for your viewership other than get a good lawyer and make sure. Like I've been approached by several clients who find themselves in this situation, and they just didn't know. They just didn't know how real this risk was. And since I've begun to do more dangerous offender work, that's become a part of the advice that I give to certain types of clients who are in the system, like Allison talks about. Once you have a probation order, it's just a hook to get you back in. Often, there are rehabilitative aspects to it. They do have psychiatrists who work out of those offices, but in my experience, it's more often a hook to bring them back in.
Right.
And if you have a criminal record with enough, I was going to say with enough violent offenses, but they don't even really need to be. There needs to be some element of violence because there needs to be a concern to the public at large. But yeah, other than that, other than being careful in the decisions you make, both within and outside of the criminal justice system, I think the problem that we're really addressing here, it's a systemic problem. It's not a problem that's brought on by our clients.
Right. Thank you very much. Now, we're just coming off to a close now. I want to get the opportunity, if Allison, before we go, I would like for you to maybe tell our viewers about your law firm and your contact information, where they're able to reach you. You never know. Our phones ring constantly. So.
Yeah, you never know. My firm is called Posner, Craig and Stein, and you can find us online at pcslaw.ca.
Thank you. And Brian?
It's bedefended.ca or my last name.ca, EBERDT.ca. We can be reached toll free. We accept collect calls, 647-812-1675. We do have a toll free number, but I'll go to the website. You'll find it there.
Thank you so much. Well, folks, it's a very important topic we had a discussion on tonight. It's my pleasure for Allison and Brian to take the time out to give us some valuable information on this well needed topic. I'm very much aware that we've had a lot of ask about this topic, and I wanted to come out personally myself, and I was able to bring these wonderful experts here to the table here with their views. Again, it's a pleasure. Stay tuned. You can follow this episode on our YouTube at Keep, KEEP, the number 6IX, and also on our Facebook and our Instagram Live. We thank you all for joining us tonight, and look forward for our next episode coming up soon. For advertising, we'll fill you in on that coming up soon. And thank you all, and see you again soon. Thank you, Allison, and thank you, Brian. Have a good night.
Thanks, Richard. Take care, guys.
Thanks, Richard. Good night.